This is my presentation. The title of my presentation is E-contracts and their impact on online commerce. First, I'll be overviewing e-contracts and governing laws. The basic e-contract requirements are the offer, which must be clear for both parties, the acceptance, which should bind the offeree to the contract offered by the offerer. Third is the awareness. Both parties must be aware that they are entering into an agreement. Fourth is the consideration. There should be mutual assent when two parties are binded to an objective agreement, such as on the value of a service or a good, which shows that the offeree's intent to sign it was completely voluntary. Fifth, the capacity. Both parties must have the ability to incur legal obligations. This means that minors or persons suffering from mental illness or those unable to understand the language used in the contract cannot count as parties that are able to incur legal obligations. The sixth requirement is legality. This means that the contract must be legal under state and federal regulations. This requires that all parties follow legal um, rules and it cannot be illegal, such as it cannot be a contract about illegal activities. Other requirements in the contract are first, that all parties in the contract are identified. Second, the purpose of the contract should be stated or the terms being presented should be clear at the front of the contract. Third is that the payment terms should determine the method of payments and when those payments are going to be made. Fourth, party obligations, responsibilities, and expectations should also be included in detail. Fifth, any declarations or representations and warranties should be included so as to reassure parties about the factual nature of the contract itself. This means that there should be true statements in the contract which declare to each party the following factual pieces of information. Six, other clauses or termination conditions. And finally, any form of e-signature should be at the end of the contract. There are a couple of different online contract types. There's the browser wrap agreement, which is a type of contract where users are just binded to the contract simply by surfing the web. For example, when they enter a site or start to use it, the browser's activity makes it an implied contract. The second is the click agreement, which any type of e-contract where users agree by clicking an I agree button or I consent. This is a form of contract called the click agreement. It's a form of express contract because it requires the users to take a specific action. Thirdly, the scroll wrap agreement is a type of contract where users are required to scroll through a set of terms and conditions before they purchase an item, such as a software program or an online purchase. This type of contract requires them to scroll through all terms and conditions, reading carefully before submitting. Signing wrap is a type of e-contract where users must sign up before using a website or an application. This means that they must sign up um, or make an account so as to use the website. The shrink wrap agreement is a type of e-contract which comes with the software's product plastic packaging. This means that the purchaser breaks the seal, opens the package, or uses the software in any form of opening the package counts as a form of acceptance of the contract's terms. Other types of online agreements include contracts for employment, international shipping, financial transactions, wills and trusts, sale of real estate or personal property, etc. The ClickUp and browse agreements are perfect for virtual transactions. For example, both ClickUp agreements and browse swap agreements are labeled as virtual transactions and governing policies before they are purchased. The formation of a legally enforceable online sales contract requires the seller to demonstrate that the buyer received adequate notice of the terms and conditions governing the transaction and affirmatively assented to those terms before completing the purchase. This allows the consumer to have a checkbox so as to measure intent. This is part of the clear agreement, which is a very simple way of detecting a consumer's intent to buy a product. When discussing the behavior of a consumer, the purchase is directly from the online site. In contrast, the browser agreement binds the online buyers to an e-contract just by using the website. This makes it more challenging to enforce this type of contract since it requires that the user show that they really intended to use um, the agreement in discussion. In many agreements, the owner always explicitly notifies consumers about important information before they order, but consumers can demonstrate insufficient evidence of notice of terms. So this can happen very specifically through implied contracts, such as a browse-up agreement, in which most agreements are tied to an implied statement. Explicit contracts like the clear agreement are better because they are more verbose and typically are more legally enforceable for online sites. The key differences between traditional and e-contract is that the difference lies in how consent is captured and documented. E-contracts can involve electronic entries and is often simpler to execute. Traditional contracts require physical signatures and may involve more formalities. In 2017, about 754 million transactions were signed electronically. This shows that there's a great difference between e-contracts and traditional contracts. E-contracts are growing in number as the number of e-signatures are increasing compared to traditional contracts, which is a more manual form of agreement. There are about two different types of governing laws for e-contracts. The first one is the Uniform Commercial Code, and the second is the Common Law of Contracts. They all serve basically the backbone of all contracts that are applicable. Contracts that are applicable are those that follow the six basic requirements, and in some cases, e-contracts are governed by the same principles as traditional ones. Specifically, Article 2 in the UCC applies to contracts for the sale of goods. The law of contracts, on the other hand, governs services and other types of contracts that are not directly governed by the UCC or may be questioned for enforceability. The law of contract requires that a contract contains elements of mutual assent, just as discussed acceptance, offer, consideration, capacity, and legality. Some special instances of online contract governance include the Uniform Computer Information Transactions Act, which is a key statute in governing e-contracts. It provides guidelines for the formation, enforcement, and interpretation. The UETA also is another special instance which validates and enforces e-signatures as acceptable forms of contractual agreement. This is very similar to traditional handwritten documentation, in which if there's an intent to sign, e-signatures count the same and have the same legal weight as handwritten signatures. E-sign grants these types of validity under the ground that they are electronic signatures that match handwritten signatures. In fact, e-contracts are governed by the same standards as traditional contracts. Both parties must comply with state and federal electronic signature laws like e-sign and UTA. Compliance with governing are a must for enforceable e-contracts. E-signature governance. The UTA and the e-sign have been accepted by U.S. courts in an effort to address certain issues having to do with agreement terms between two parties. Typically, for the courts to validate e-signatures for e-contract, the parties must adhere to the following terms. The first one is that they must agree to notice of terms. The second is that they must assent to the terms. Third, the signatures must have sufficient degree of authentication. And fourthly, they must agree to transact electronically. So e-sign and UTA apply when both parties make sure that they are agreeing to the same terms. There are some arguments for online sales tax, and I consider the best approach noticing the interplay that e-contracts have with online sales tax and virtual transactions. The best legal approach um, requires analyzing the support for sales tax and the argument against sales tax for online purchases. The support shows that state and local governments lose billions of dollars in tax revenue. They argue that this money can be used for governmental public institutions like hospitals, construction, schools, or public safety. Other proponents of online sales tax considers sales tax charges as a way to level the playing field between brick and mortar businesses and online shops. Also, following the Marketplace Fairness Act, which was enacted in 2013, retailers that mainly use online services were required to collect sales tax. They argue that this act will help federal government overcome tax compliance issues. The arguments against sales tax for online purchases is that if online sales tax is charged on all online purchases, consumers will have to comply with drastic increases in sales tax. This could drive many away from online shopping. Another another opposer uh, considers that current laws prevent consumers from tax-free environments. These tax-free environments are flexible when when they are given to consumers who make online purchases. For example, some may contact pickup services and they could pick it up at a local store through an online medium. Others may place tax exempt orders or certain states making some items tax exempt. Another key argument is that some states like Alaska, Delaware, Montana, New Hampshire, and Oregon do not collect taxes. So any form of nationwide collection of sales tax could make the process to enforce these tax compliances more complicated than it is. With over 30,000 taxing jurisdictions, online sales tax can become very tricky since the internet is very susceptible to heavy tax penalties. Unlike physical uh, retail retail shops, the internet shops can be very taxed more, even including the double of tax that retailers that have a physical presence in a state may be collected from. As costs of compliance have risen to 87% for small online businesses, opponents fear that an avalanche of audits could put many online shops out of business. In effect, this could cause many new entrepreneurs who want to form new online businesses to discontinue their business, and this could deter the creation of new online businesses. Some pros and cons of online sales tax on purchases are that there might be an increase in tax compliance for small business, which could stifle e-commerce. Another con would be that it would be unfair for online businesses to be taxed at the same rate as local retailers by consumption of government services. Another con would be that there are cases where e-contracts fail to provide consumers with important information. For instance, online businesses have been accused of invasion of privacy by coercing consumers to buying the products or buying important terms in fine print. There are pros for online sales tax contract. On the other hand, for example, states and districts will gain more revenue and contribute more to governmental public institutions or services such as healthcare, national defense, education, infrastructure. Another pro would be that sales tax simplification in 31 states could improve the government's ability to collect taxes naturally, and by simplifying this process, it is possible to enact a sales tax for online purchases. Another pro would be that it would bring competitive fairness between online businesses and brick and mortar retailers. Local retailers would be able to thrive under an even level playing field, instead of online businesses taking the playing field for themselves by not charging taxes to some consumers. All online business could have a fair share in the marketplace, including brick and mortar businesses. The best approach to online contracts, in my opinion, is that the best way to think about it is to consider the economic effects of enforcing these types of sales tax compliance systems. There's the impact that it will have on the creation of new businesses or the ability for the consumers to make valid transactions with these online businesses. It is very common for tax to be evaded um, for online business and customers alike. It is important to have contracts that are properly enforced and validated, as it can here to lead to higher tax penalties. In conclusion, a valid enforceable tax collection contract would require a negotiable agreement between online businesses and the government. For the contract to work, the e-contract must be enforceable, and should be validated based on agreements that are granting out-of-state governments the authority to regulate online businesses with regard to online taxation. The expectations of such an e-contract would be that they agree to the terms and conditions that ensure customer privacy. Second, parties should be informed before they negotiate an agreement. If personal documentation is needed to collect taxes, consumers would be notified through a click-wrap or browse-wrap agreement, since they both outline legal steps for consumers to take if they purchase an item. ClickUp and browser agreements are the best types of e-contracts for this type of case, especially dealing with virtual transactions that could harm the privacy of certain customers. Thirdly, considering the legal obligations of e-businesses, the best practice in sales tax is to keep a detailed record of sales and those that agree to the e-contract in order for tax jurisdictions to review them. The key takeaways is that an e-contract is a promise to protect online agreements between two parties that show intent to sign. Contract obligations require mutual agreement or an exchange of value. Another key takeaway is that e-contracts are relevant to online sales tax, since contractual agreements allow virtual transactions to occur over the internet. Thirdly, the click-through agreements such as browse wrap and clear agreements are used in different situations involving virtual transactions and sales tax. They are the perfect alternative for proponents of the sales tax um, to govern certain types of policies that allow online businesses and governments to work together to collect taxes and to provide support for public institutions like schools, educations, and infrastructure, including public safety. Online sales tax can be handled by e-contracts, and these e-contracts are governed by laws that evaluate the enforceability and legal weight, such as the law of common contracts and the Uniform Commercial Code. They are used for virtual or commercial transactions. So my references, and thank you very much for listening.